Okay, this is my best legal argument, for your right to obtain reasonable knowledge to make an informed decision, to give informed consent. And that reasonable knowledge would be the legal knowledge that equal to those working under the color of law in a court of law. And those are attorneys and judges. Because if they haven't reviewed anything I've reviewed with you, and I don't know, almost 400 videos, and then they're not working for you, they're working for themselves. Okay, the right to counsel, that's what I wanted to talk to you about. In the U.S., the right to counsel is not guaranteed in all situations. It's primarily a constitutional right for criminal defendants facing potential jail time. If you cannot afford a lawyer, the government must provide one. E.g., public defender, the offense like felonies and serious misdemeanors. The right to counsel is restricted by specific legal rules. Criminal versus civil cases, the right to government-appointed attorney only applies to criminal prosecutions. It does not apply to civil matters like divorces, child custody disputes, or evictions. In these cases, you are allowed to hire a lawyer, but one will not be provided for you. Potential for incarceration if the offense is minor does not carry the possibility of jail or prison time. Courts are not required to provide a free attorney. Custodial interrogations. The Fifth Amendment grants you the right to have an attorney present during police interrogations if you are in custody. You can learn more about the exact scope of limitations of right to counsel to the National Association of Criminal Procedures. So it's telling you only have a right to counsel in criminal cases, and that's if you're going to have to do prison time. But not does not apply to civil matters like divorces. In divorce court, just like in any other court, the win goes to those with the heaviest purse strings. Child custody dispute. I've seen children go from the good parent to the mean parent because the mean parent had means, monetary means, money. It was a father against the mother. She gave the father custody. She was having some medical issues. And once they were resolved, mental health issues, and once they were resolved, she always kept in contact with her children, and they eventually decided they wanted to move back with her. She was the attentive parent, gave them time. She didn't have a lot of money, but what she did, she gave them. She gave them time. She did things with them, spent time with them, to where the father didn't. But the court made the kids move back with the dad because the dad had the lawyer. And she got public aid, or I think that's what it's called, or legal aid, and they sat back and did nothing, and which was totally ineffective assistance of counsel, defective assistance of counsel, destructive. I've helped a lot of people in eviction courts. I'm going through eviction court right now. I don't have the right to counsel. They're not going to appoint me one. They tried to get me to take one through an early resolution program, but that's just nothing other than putting me in mediation. And that was just some lawyers that were going to try to convince me just to pay a lot of money and get a lawyer. And but the simple fact is that the landlord refuses to make any of these mandatory major repairs for multiple water leaks, rust in the water. Sometimes black stuff comes out, black mold growing in the bathroom, coming up through the bathroom drain, and the front door needs to be replaced. It's tilted, slanted. It doesn't really do what it's supposed to in its entirety. So I'm going to use the rules of professional conduct, even though I'm not entitled to a lawyer. But in the rules of professional conduct, it clearly states that all lawyers are to do what's in the public interest. And in fairness to the opposing party, it would have been diligent for him to communicate to his client the legal mandatories of making these repairs. And I told him I told the landlord, you could even look it up on the internet. The landlord fixes everything. I says, didn't your lawyer tell you about this? Oh, well, no. He said that's because you did, something about the people that used to own the building. They were supposed to do it. They didn't do it. It was on them. Not. I said, no. I said, clearly a disclosure law. I said, are you familiar with the disclosure law? I says, your lawyer should have told you about that. But when you take possession of a property, you not only take possession of the property, but the problems that come with it. And you're supposed to set up a schedule between you and the old landlord. They're supposed to let you know about all these things, and you're supposed to fix them. Set up a schedule and let everybody know, and, look up disclosure law. So it would have been diligent that his lawyer communicated to him, and he looked pissed and kind of surprised. I said, "Talk to your attorney. Let me talk to him." And so it went from the landlord threatening to evict me. First, he was saying I wasn't paying the rent, but I was paying the rent, and then it came down to me not paying the rent increase. So he was evicting me for refusing to do that, but he found out he couldn't do that because he didn't make all these mandatory repairs. And his lawyer didn't tell him. I don't know. Either or they're just working together to deprive me of my right to clean water, habitable living conditions, and where it doesn't rain on me while I'm sitting on the toilet. They finally fixed the toilet, and I'm handicapped and trying to get on that toilet, sit down, and it would wobble. It used to scare the crap out of me, literally, while you're on the toilet, getting this, it just, But, so they're colluding to deprive me of my right to, clean drinking water. The last landlord told me that's on the government. I said, no, it's on them to get clean water here. Once it hits this property, that's on you. And she had some guy come out here, and he told me I have to understand the building's old, and I told him about the repairs. He says he knows, and they're going to do what they can. He'll inform the landlady. They didn't make any repairs. They just sold the building, and she was pissed because I wouldn't sign a lease, and I wouldn't sign a lease or pay the rent increase because she wouldn't make these repairs, and she knows she can't ask for more money the worse the problem gets without, lack of maintenance. That's all it is. No preventive maintenance, no maintenance at all. So this is deprivation of rights, a conspiracy to deprive rights under the color of law. And the judge allowed it to go this far. We could have resolved it on the first day, but the judge denied me my right to be heard, which is a constitutional right, and it's also the Code of Judicial Conduct's Canon 2, Rule 2.15, the right to be heard. She denied me that. So she added, this was a furtherance in a conspiracy against rights under the color of law. So, it's easy to put together that case using the rules of professional conduct, against the opposing party. So in fairness to the opposing party, it would have been competent. It would have been diligent for him to communicate to his client that he can't be breaking no laws. Okay. So that's my best argument, for you to get a legal education. And even the law says, I don't know why I remember this stuff, but I guess because I read it so many times. But even law says the legal profession, relative autonomy, carries special responsibilities of self-government. The profession has a responsibility to ensure that its regulations are conceived in the public interest in not furtherance of parochial or self-interest concerns of the bar. Every lawyer is responsible for observance of the rules of professional conduct. The lawyer should also aid in securing their observance by others, and lawyers neglecting these responsibilities compromise the independence of the profession and the public interest which it serves. Lawyers play a vital role in the preservation of society. The fulfillment of this role requires an understanding by lawyers of their relationship of our legal system. The rules of professional conduct, when properly applied, serve to define that relationship. Okay, you didn't know about this because you're just hearing it from me. And these are the legal responsibilities of all lawyers and judges, and they don't do it. That's why I keep telling you, everybody, you got to learn the rules of professional conduct, code of judicial conduct. This ain't going to happen if you don't take copies of this stuff and go over with the lawyers and the judges in a court of law to make sure everybody plays by the book. That's the only way. And then they're going to try to use a language you don't understand, so you can demand to keep it in layman's terms. Okay, make your demands. I've helped people through jury trials. Most of the time they drop the case because they don't want to go to a jury trial. They don't want to have a quick and speedy trial. They don't want to go to trial because they don't have any evidence. They were trying to convince these people just to take the plea and leave with a felony. But sometimes they did take it to trial, and I told these people, pick your own jury. You're going to count on those lawyers? They're going to pick people that think like they do, or they're easy, to manipulate to get them to... No. What you want to do, you have a right to a jury of your peers. I had some idiot public defender. Oh, what do you think we're going to do? Go find his friends and have them judge him, She was a real idiot. I mean, I don't know how she made it through law school. I don't know how she passed the bar, but from day one for almost a year, she spent trying to convince this kid just take the plea deal. She exceeded limitations on a quick and speedy trial, and no matter how many times I brought it up, the judge didn't care, the state's attorney didn't care, the public defender didn't care. All they cared about was this kid copping out, and they were pissed because he took a jury trial. So they decided, okay, you want a quick and speedy trial, and they had it that day, and the only witness they had was the cop. And when he got on the stand, he perjured himself. He arrested 7 people, said he saw them all spray painting. So I had the public defender use the police report where he said he saw all 7 spray painting and arrested all 7, but he only had 2 cans of spray paint, and those spray paints weren't the same color as the paint on the wall. Different colors from the writing on the wall. I know, I took pictures. I investigated the whole case, as far as what there was to investigate. So they said, so they had 6 convictions. This would have been number 7. He said he saw all 7 of them spray painting. So the questions the kid had told the public defender, asked, okay, so you got 6 convictions. This will be number 7. He says, yes. And you testified, well, it's okay. So 5 took a plea deal, and number 6 finally took a plea deal in the end. And this one didn't, so they only 2 cans of spray paint. Okay, officer, you said you saw all 7 of them spray painting when you pulled up on them and arrested them. Okay, which 4 were holding this spray paint, this can, and which 3 were holding this can? And the judge called for a sidebar. Everybody went in the back. The judge came back out and dismissed the jury, apologized for wasting their time. They didn't get the cop for perjuring himself, false arrest, These kids didn't do it. The kids that were spray painting, they were doing it around the corner. When the cops came, they took off ran past these kids, and these kids just stood there, and their dumbasses thought that they didn't do nothing, so there was nothing. They weren't going to get arrested. When the cops arrested them, they said, we didn't do nothing. It was those guys, Cops told them, wrong place, wrong time. So in the end, if that kid didn't have me, and I didn't have access to the internet, but I had the rules of professional conduct and the code of judicial conduct with me, and even though I quoted them in the court of law, nobody cared about it. But now that's why I always push for cameras in the court. All right, so this is usurpations of the law, okay? Usurpation refers to the act of wrongfully or illegal seizing or holding power, property, or rights by force without legal authority. It is a plural of repeated from usurpation, commonly used for describe unauthorized encroachments on someone else's sovereignty, authority, and or legitimate possessions. Okay. Oh, sorry. The founding fathers viewed usurpations as unlawful, unauthorized seizure of property. In Declaration of Independence, they famously declared that when a government embarks on a long train of abuses and usurpations to establish absolute despotism, it is the right and duty of the people to throw off that government. Okay, so right now, no matter what court of law you're in, you're dealing with ineffective assistance of counsel, judicial misconduct, multiple counsel conduct on the opposing party, whether it be in civil, divorce, child custody, or criminal court. In criminal court, that would be prosecutorial misconduct. So already, just by going over what I've been talking to you about, is already showing you usurpations. When they talk about it was before the Constitution was written, but these usurpations were depriving one of life, liberty, and the pursuit of happiness. So without effective assistance of counsel or appointment of effective assistance of counsel, how are you legally able to maintain your life, liberty, and pursuit of happiness? Now you're starting to understand that all your life you've been living in fear of your life, liberty, and pursuit of happiness. And the only way you can cure that is to get that legal education, and you could possibly spend the time I did in educating yourself, or you could take a shortcut, go through all my damn videos, which will take a while. But I think it should be started earlier. Like when I started, I first read the Constitution when I was 10 years old. I didn't understand it, first read, it took me a few, 3 or 4. But the more I read it, the more I understood, the easier it was to understand. And this due process thing I had to find out. And, growing up in the 60s, the 70s, what they call what was going on at the time, the civil rights movement. But all it was demand for recognition for the rule of law. In the Declaration and the Constitution, they both have a common denominator, and that is where it says that we are endowed by our Creator with certain inalienable rights. Amongst these are life, liberty, pursuit of happiness, and that's being denied. And that's being denied because you don't have the reasonable knowledge to make an informed decision, to give informed consent in any court of law. And nobody's given it to you. So you have to inform yourself about informed consent. You can Google it, inform yourself about informed consent. I was going to make a video, so I figured I'd Google it. And hey, there's already people talking about it, okay? So you're going to have to inform yourself about informed consent, okay? Let's go there. Okay. Informed consent is an ethical legal process ensuring patients or research participants fully understand proposed procedure, treatment, and study. So this is medical as well as legal respects, okay? Disclosure, the provider must clearly explain the condition, recommendation, intervention, potential risks. Okay, so some people I was talking to about medications given to their children, and there wasn't any testing done. There was some side effects, unexpected side effects. This lady, her kid was hallucinating and seeing things, and these weren't mentioned. And I told her, well, how long were you there? Just a couple of minutes. She told the doctor. The doctor wrote a prescription. The nurse came back with the prescription and a return date, and she went back because of the medication's ill effects. And so I told her, oh, you didn't give him informed consent. So what do you mean? I said, you went there to find out what was wrong with your kid, and he just wrote a prescription. There's tests that could be done. I mean, if you want real answers, or you want to go with the guessing game. If you're going with the guessing game, no, that's not giving you, that you're not giving informed consent, and he's not asking for it. He's just going by an educated guess, and for that much, you can get that from a carny at your local carnival. Okay, so no more guessing, people. Okay, but this is in the legal context too. You can just put down it. Legal context, informed consent is a doctrine that protects patient. Okay. Okay. Well, it always goes to doctors first. Let's go AI mode. See, right here. Inform yourself about informed consent. Illinois Bar Association. Okay. Are you reading it? Should I read it? Nearly third Illinois ethics rules require lawyers to get clients informed consent before proceeding. So what is informed consent? Here's a look at the concept and the issues that it raises. Okay. So I went over this before they put AI in there to. But I'm glad, though. I ain't hating. I ain't got to explain. People always give me a link, before I started doing legal reform and posting these videos as unaccompanied adult, as Mario on YouTube. My YouTube is called The Vent. And, but really, people, inform yourself about informed consent. Okay? And that's in the legal context. And you'll never get that if you don't have the legal knowledge or the reasonable knowledge to make an informed decision to give informed consent. And that is the legal knowledge of those that are supposed to be representing. Those are supposed to be in court of law doing what's in the interest of justice, And let me show you what it says. I'm going to use the Illinois one. Okay. Where was I going to? Oh yeah, Rule 3.8. Truthful. You see, you're not gonna. A lot of this stuff is gonna truthful statements to others. Okay, let's go there. And then down here. See, you could say this for any attorney. The United States attorney is a representative not of an ordinary party of controversy, but a sovereignty whose obligations is to govern impartially, and it is compelling as it is obligation to govern at all, and whose interest, therefore, in a criminal prosecution is not that it shall win a case, but that justice shall be done. As such, he is in particular a definite sense of servant of the law, a twofold aim of which is that the guilt shall not escape or the innocent suffer. He may prosecute with eagerness and vigor indeed, but he should do so. But while he may strike hard blows, he is not liberty to strike foul ones. It is much his duty to refrain from improper methods calculated to produce a wrongful conviction as it is to use every legitimate means to bring about a just one. But that can be said for all attorneys in every court. Okay. So I'm just pointing this out to you, okay? I'm not a wordsmith. I don't think I have the ability to put this stuff together. I just like to read a lot. But personally and legally, and if I were a lawyer, I would say, in my legal opinion, the only way you'll ever get effective assistance of counsel is to get a law degree, pass the bar. Because nobody's going to do any of this. They're not. That's why you're watching my videos, okay? See, all these are laws. The rules of professional conduct, those are your constitutional rights. The codes and the code of judicial conduct, those are your constitutional rights. That is what gives you effective assistance of counsel. If I were president, if I were anybody in Congress, I would say, hey, it's the only way we're going to fix this crooked system is if everybody didn't need a lawyer, because, all these kids took the bar before they graduated from high school, or when they graduated from high school. If I had my way, that's what I would do. I'd make sure, there's at least 2 lawyers in every family. That's the only way you're going to stop from living under the color of law. That's the only way you're going to stop anybody from acting under the color of law, is to learn the law yourself. In a nation of laws, all laws should matter. And all the laws your public servants are breaking, nobody's being held accountable. And there's penalties for all of that. And I've been showing you. And they're supposed to be held to a higher standard. And if they're held to any standard at all, it's, for the most part, a slap on the wrist. If they send some public servant to prison for murder, they get 5, 6, 7 years. But if they aren't a public servant, they could get life without parole or the death penalty. It's ridiculous how they hold themselves. The standard is so low, you know, that an ant couldn't crawl under. All right, people, nothing but peace and love. You know, may your Creator always be with you and rain many blessings. I wish you a long life and good health. Good night.